law really only applies to a sort of international quasi-criminal and individual rights, and to that I simply disagree with that. So some people have criticized the bill because it incorporates environmental and labor rights, for example. And the reason it does that is because we know, obviously, that Canadian corporations and the Canadian actors commit gross violations of environmental legislation and regulation, and they have, many of them have terrible and appalling violent labor practices throughout the world. And so we need to get at more than just, not that they're not important, obviously, the core human rights violations. The second thing that the bill does, it creates a cause of action, and it provides that essentially it excuses any kind of limitation period that could possibly be applied if there's a good reason to do so. And third, and I think this is probably the most, in some ways the most important piece of the legislation, is that it modifies the existing test to ensure that courts currently apply in Canadian law to prevent these cases from being heard in Canada. And that's sometimes called, and I am going to speak Latin, forum non conveniens, which essentially means that under current Canadian legislation, if a Canadian court finds that these kinds of lawsuits can be heard in the forum where the violations occur, then they are automatically dismissed. All right, so a whole raft of Canadian lawsuits have been dismissed on that basis. They've been dismissed on other bases as well, but a whole raft have been dismissed on that basis. So the legislation would modify the test to ensure that the onus would actually shift to the defendant to be able to clearly establish that the matter in question can be fairly and effectively heard in another forum, or in, let's say, the country where the violations have occurred. And that they can be heard not only fairly and effectively, but that the people who are seeking justice can get justice by a final and binding decision that can be achieved in a timely manner. So again, the purpose is not to provide basically Canadian courts with the authority to hear every human, labor, and environmental violation that might occur anywhere in the world. The purpose is, I think, a purpose that most people can agree on, is that where individuals can't get justice in the jurisdiction where the violations are taking place, and the party committing those violations is Canadian, those people ought to be able to get justice in Canada. That's the basic premise of the bill. It's not particularly complicated, and it shouldn't be particularly controversial. So why then, just let me finish before we get to questions. It's now 2:45. Why, I mean, I'll give you just a bunch of reasons why I think at least this bill ought to be supported, and we ought to try and build a campaign around it. First, it sends a clear message to Canadian courts that they ought to be hearing these kinds of cases. The reality is, Canadian courts and Canadian judges, like for example in the Copper Mesa case, which is a case you may hear about tomorrow, which you may well be familiar, in that case, when he dismissed the case, Justice Campbell, in his decision dismissing the case, specifically said, I think that there is a case to be heard here. I think that the people whose rights have been violated by Copper Mesa ought to have a place where they can get a remedy, but the problem is we just don't have the statute in Canada to do that. And he all but said there ought to be legislative reform on this issue, all right? Former Supreme Court of Canada Justice Ian Binney, after he had left the court, wrote an article in which he also advocated for some sort of legislation that would sort of, again, close this kind of accountability gap that we clearly see, and that a whole bunch of lawsuits have been trying to get at unsuccessfully, because again, legislatures haven't sent the messages to courts that they should feel comfortable hearing these cases. So that's the first reason why we really need legislation. The second argument that I make in favor of this legislation is one I've already made to you, which is that we need to have a statute that protects a broad range of rights and not a narrow. Some people want to focus especially on criminal issues or on a more narrow range of rights, or they want to focus more on a sort of corporate social responsibility angle. I think, again, the purpose, the beauty of this legislation is that it protects a broad range of rights. Third, it creates a civil cause of action. And this is, again, back to our experience with the Alien Tort Claims Act. The virtue of creating a civil cause of action, as opposed to what Bill C-300 did, which was essentially create a regulatory regime, is several. First, a civil cause of action allows the actual victims to come to court and actually tell their story before a court. And I think that virtue alone should not be underestimated. It can become an effective platform for the illumination of these issues to the general public. All right, that's the first virtue of it. Second, it gives the actual victims of these rights abuses the authority to actually drive the process. Right? The problem with government-driven processes is that they're driven by governments, and governments change, and governments are sometimes committed to enforcing rights, and sometimes they're really not. And so, again, creating a civil cause of action gives the actual victims of the abuse the ability to actually drive the process, to decide how they want to proceed with the case, and to decide ultimately whether the resolution is satisfactory to them or not satisfactory to them. And that brings me to the third advantage of a civil cause of action, is that hopefully it could actually provide real damages and real remedies to the real people who are actually harmed by the corporations that you've been hearing about today and tomorrow. Right? Again, a regulatory process tends to lead to slaps on the wrists or fines or the withdrawal of CPP funds or whatever it might be, but it doesn't actually provide the real remedies to the actual communities that are affected by the actions of Canadian multinationals. The third, so that's, again, the final reason why this bill, I think, should be supported is that there is actually a model for it, right? People say, some people, particularly in the legal world, think that this kind of bill is sort of completely outside the realm of possibility, but the reality is it's not. There's a model for it. It's the Alien Tort Claims Act in the United States. And that act has been used, and it's currently under fairly serious attack, both by some U.S. politicians, but also by U.S. courts, and we can talk about that if you like. But nonetheless, there is a model that proves that this kind of litigation is possible, and it can lead to actual real results. So that's really all I want to say. I mean, I will give you a couple of quotes. I was very pleased recently. I know that I'm making progress when the Fraser Institute starts writing about something. Some guy named Fred McMahon, who is the Vice President of International Policy Research at the Fraser Institute. It's sort of odd corporate, like Vice President of International Policy Research. Anyway. Wrote an article about Bill C-323 within the last month entitled, quote, "Another Threat to Canada's Mining Industry." And even he so the gist of the article is, well, phew, we got over Bill C-300, but watch out, because here comes this Bill C-323. It, quote, "leaves Canadian firms vulnerable to huge risks and costs." One blog supporting the bill notes that Canadian companies are risk averse, so the law, I even concedes, will be effective. And then he says that's likely right, because Canadian companies are risk averse. I'm not sure I agree that Canadian companies are risk averse, but I do think we're in a political moment right now where I think we all know that there's not going to be any movement on these political movement, if I can be very clear, or legislative movement on these issues until there's another federal election. So we're in a moment where we can engage in forums like this, and obviously I'm not suggesting for a minute or for a second that this kind of legislative action should come in lieu of all the other various actions that you're going to be talking about. But if you're thinking about policy initiatives and legislative initiatives, we're in a moment where we have a couple of years to actually think about this, to develop a coherent legislative agenda, And then hopefully when the federal government changes in 2015, we'll be in a position to actually be able to change laws to actually hold corporations and Canadian actors accountable for their actions. And I actually don't think that this bill, some people characterize this bill as being too sort of dramatic and radical, as being a more radical version of Bill C-300. I've been told a number of times, well, how, you couldn't pass C-300, how are you going to pass Bill C-323? And as the brother said, all that we're suggesting is that where people's rights are are egregiously violated, they ought to have a remedy somewhere. And if they can't have a remedy in the jurisdiction where the rights violation occurs, then they ought to be able to come before a Canadian court and get justice. That's not that much to ask at the end of the day. And so I do think that actually there's a strong public case to be made for the bill. So I look forward to your questions. Thank you.
We'll open it up. So we'll take a couple questions at a time, 3, and then we'll start in the back with Christine.
Yes.